6. The officer references a 911 call that identified Brian Laundrie pushing Gabby Petito away from him, and then says there is a second witness who they haven't spoken with yet but may corroborate this claim. The 911 call of the second witness in fact claims Brian Laundrie slapped Gabby Petito. Should the officer have obtained this statement from the second witness or listened to the 911 call before determining who was the primary aggressor? There was only one 911 call in reference to this incident. That caller reported Brian slapping Gabby. The other witness was found on scene at the Moonflower and provided a verbal and written statement later on. This issue is addressed in more detail later on in the report. But in short, the answer would be yes, the officers should have obtained a statement from the 911 caller before making a final determination, if it was possible for them to do so. 7. The officers twisted themselves into knots trying to find a way to avoid effecting an arrest or citation because of their sympathy for this couple and their assessment that no one was actually in danger, which is precisely what the legislature attempted to curtail, substituting the judgment of the officers for the mandates of the legislation. I believe it is clear from the body-worn camera footage that stating the officers twisted themselves into knots trying to find way to avoid effecting an arrest is a gross mischaracterization of what actually happened. Law enforcement is being second-guessed, now more than ever, which has led to officers taking more caution and time as allowed before making a decision to try and avoid the inevitable second-guessing. These officers were authentic in their interactions and treated Brian and Gabby with kindness and respect. I would say the officers displayed sympathy and empathy for this couple, which undoubtedly led to Officer Pratt second-guessing himself, despite the fact he said multiple times what needed to happen. Officer Pratt resorted to calling a supervisor and then rereading the assault statute. From there, the statute is not fully read, and what was read was misinterpreted, which led to not arresting anyone in this incident. 8. The officer concluded in his report that he did not believe the incident rose to the level of domestic assault so much as a mental health crisis. Have officers received sufficient training in mental illness and domestic violence to accurately make that determination? I was unable to answer this question in full, but asked both officers for an explanation into why they categorized this incident in such a way. Their responses are documented later on in this report. 9. One additional concern I wish to add to my complaint is the officer's lack of investigatory follow-up after Gabby Petito told him that Brian had grabbed her face with his fingers, digging in to the point of causing a cut on the inside of her cheek. It was hard to discern her exact words, although I did hear the word cut, but she seemed to indicate that her cheek was swelling up or tender, and she cupped it with her hand as she described the injury. The very first question the officer asked in response to this was if Brian had been drinking. His very next question returns to the swerve and curb strike incident. In the footage available to me, he never returns to Gabby's allegation of a crime to ask more questions, investigate, or follow up in any manner. The officers seemed distracted by the centerline swerve and curb strike and the admission that Gabby had punched Brian in the shoulder when the lights were activated. They spend the majority of the investigation pursuing this allegation, while the reason for the initial detention, the two 911 calls reporting a man slapping a woman, fell by the wayside. Even when Gabby reports a battery that caused injury, her statement is entirely ignored because the officers seem to be operating under a confirmation bias that influenced how they interpret the evidence and their theory of the case. Brian was thoroughly examined for evidence, including an examination underneath his clothing for injuries of which he may not be aware. Photographic evidence was obtained, and he was offered EMS services for his injuries. None of this appears to have been provided to Gabby Petito, even after she reported a battery resulting in injury. These concerns are addressed in multiple sections throughout this report. Utah State Code, Powers and Duties to Arrest, Utah State Code 77362. 2. 1. The primary duty of law enforcement officers responding to a domestic violence call is to protect the victim and enforce the law. Sustained. 2. A. In addition to the arrest powers described in Section July 2nd, 77, when a peace officer responds to a domestic violence call and has probable cause to believe that an act of domestic violence has been committed, the peace officer shall arrest without a warrant or shall issue a citation to any person that the peace officer has probable cause to believe has committed an act of domestic violence. Sustain this incident from the beginning was classified as an assault that took place between a male and a female. During the investigation, it was found they were cohabitants. It is my finding that an assault did take place, therefore should be classified as a domestic violence investigation. This incident starts with both witnesses, who included the witness that called 911 and reported Brian slapping Gabby, to a second witness that stated Gabby was hitting Brian, and Brian pushed or shoved Gabby. It continued on with the roadside investigation and statements made by both Brian and Gabby. I have already documented the many statements they each made to law enforcement. In short, Brian and Gabby each acknowledge a verbal argument that escalated into a physical confrontation. Brian and Gabby each acknowledge getting physical with the other. It was also concluded Brian and Gabby were cohabitants due to their statements that they were engaged and living together. There were four statements made, with three of the statements being fairly consistent stories: Gabby, Brian, and one of the two witnesses. A combination of using all of these individual statements along with the observations and physical evidence would point towards Gabby being the predominant aggressor, at least as it relates to this specific incident. As it relates to the fourth witness, contact was not made with him outside the 911 call, so there is no written statement and no formal interview conducted. In his statement to dispatch, he stated he saw the gentleman slapping the girl, stated he was driving when he first observed Brian and Gabby, stated he pulled over and continued observation of the couple, then said the male and female ran up and down the sidewalk where he proceeded to hit her. When speaking with Gabby, Officer Pratt shared statement to Gabby as it related to Brian hitting Gabby. Gabby replied, "To be honest, I definitely hit him first," when pressed for details. And after Gabby said Brian just grabbed her to prevent her from hitting him, Officer Pratt asks, "Did he hit you though?" Officer Pratt stresses the importance of telling the truth. Gabby replied, "I guess, but I hit him first." Officer Pratt asked where Brian hit her. Gabby stated Brian grabbed my face, I guess, while also demonstrating the action. Gabby states, "Like he didn't punch me in the face." Gabby said Brian grabbed her face and said she could feel a cut on her left cheek. Gabby stated when she touches her cheek, it burns. The end result of this investigated incident concluded with separating Brian and Gabby and not making an arrest, either by citation or custody. Based on the information provided in this specific incident, Brian would be the victim, with Gabby being the suspect. As it relates to the primary duty of law enforcement, while responding to a domestic violence call, the officers protected the victim by separating Brian from Gabby. However, I do not find that they enforced the law. They responded to a confirmed domestic violence incident, and they had evidence showing an assault had taken place. The statements of all those involved, along with the evidence presented, provided probable cause for an arrest. Officer Pratt talks in detail multiple times about the lack of discretion law enforcement officers have when it comes to domestic violence incidents. It is clear to me that an arrest, either by citation or custody, was decided would be the most appropriate action to take throughout this entire investigation. Officer Pratt describes to Gabby the actions they must take, and Gabby becomes extremely emotional, talking about how she doesn't want to be separated from Brian. Officer Pratt states they lawfully don't have discretion here. Officer Pratt tells Gabby that the best thing he can do for her at this point is to speak to a supervisor to see if he is missing something. Officer Pratt explained to Gabby he didn't think there was anything he was missing, but he would still follow up with the supervisor and ask. Officer Pratt calls Assistant Chief Palmer and explains the circumstances. Officer Pratt tells Assistant Chief Palmer at the end of the conversation that he is going to reread the statute to see if this fits or if there is a way that it doesn't fit. When speaking to Officer Robbins regarding his conversation with Assistant Chief Palmer, Officer Pratt indicates the only way they can't take action on this case is if the circumstances don't fit what the statute states. Officer Pratt stated if it fits, then they must follow the law and they must take action. In a subsequent interview with Officer Pratt and Assistant Chief Palmer, they both recalled this conversation, and their answers to what the content of the conversation was consistent. Assistant Chief Palmer stated he referred Officer Pratt to city policy and state law and to follow what fits the situation. Assistant Chief Palmer stated he was not on scene and didn't have all the facts that Officer Pratt had, so that was the gist of his advice. Officer Pratt confirmed this by stating he was told to do what fits. If it's a domestic, do a domestic. If it's not, then don't. Officer Pratt starts looking at the specific wording used in Utah Criminal Code for assault, 765102, and the definition of bodily injury, 7616014. This is where I believe Officer Pratt made a mistake by assigning the wrong culpability to the code, intentional, as well as not reading the entirety of the assault statute. According to Utah Criminal Code for assault, it states 1. Assault is A. An attempt with unlawful force or violence to do bodily injury to another, or B. An act committed with unlawful force or violence that causes bodily injury to another, or creates a substantial risk of bodily injury to another. Officer Pratt tells Officer Robbins how important it is to read the actual verbiage of what is written in the various codes. Officer Pratt talks about the verbiage of assault being the intent to do bodily injury. Officer Pratt only reads subsection A of the statute. Officer Pratt then looks up the definition of bodily injury in Utah Criminal Code and reads it to Officer Robbins. The definition in Utah Criminal Code for bodily injury states, 4. Bodily injury means physical pain, illness, or any impairment of physical condition. As it is written, intent is not written in the assault code, and as I previously said, I believe Officer Pratt made a mistake in the way he interpreted the code as well as not reading the complete code. As it relates to various crimes written throughout the Utah State Criminal Code, there are many crimes that specifies the culpability intent needed to fit a specific statute or classification. These are explained in Utah Criminal Code 762103. There are 4 culpability definitions explained, which are intentionally, knowingly, recklessly, and with criminal negligence. In Utah Criminal Code 762102, it describes the culpable mental state requirements. It states, every offense not involving strict liability shall require a culpable mental state, and when the definition of the offense does not specify a culpable mental state and the offense does not involve strict liability, intent, knowledge, or recklessness shall suffice to establish criminal responsibility. An offense shall involve strict liability if the statute defining the offense clearly indicates a legislative purpose to impose criminal responsibility for commission of the conduct prohibited by the statute without requiring proof of any culpable mental state. Since the assault statute doesn't provide a culpability requirement and it also does not label it as a strict liability offense, intent, knowledge, or recklessness is what would be required to establish criminal responsibility for assault. Officer Robbins asks Officer Pratt if the definition included attempt and intent, or attempt or intent. Officer Pratt replies stating, when you're attempting to do something, you have to intend to do it. By Officer Pratt believing assault had the highest level of culpability, intentionally, he believed that Gabby had to have acted with the intent to cause the injuries that Brian sustained, and therefore didn't believe this incident fit the statute after asking Gabby what her intent was. However, as previously explained, assault does not have an assigned culpability written in the statute. So the culpability of assault would have to meet the requirement of intent, knowledge, or recklessness.